Attorney Thomas Maag, we shared some of the comments earlier about the status of his challenge that's consolidated with other challenges against Illinois' gun and magazine ban, and the Seventh Circuit Court of Appeals still has that, and no indication as to when that's going to be resolved. But he does have a hearing set for next month on the vagueness challenge he has against the gun and magazine ban. But that's not the only thing. He's probably going to bring out the Fifth Amendment argument in that as well. But he talked about the other cases that he has, including a case that was in state court but transferred to federal court, challenging the FOID card and also challenging the venue limits bill that Governor J.B. Pritzker signed, saying that you can only file a lawsuit in Cook or Sangamon County if you're challenging Illinois law based off the Constitution. Here is Maag talking about the Myers v. Kelly case.
It's a standard FOID card challenge issue for somebody with some FOID card problems. In addition, we are challenging the new venue provision. Since filing the Myers case, we have also filed a couple of other similar challenges to the venue provision because, Illinois is continuing to violate their citizens' constitutional rights, and most of these persons don't live in Cook County or anywhere near it, and most of the citizens of this state don't live in Sangamon County, i.e. Springfield. So at this point, I think we've got four different cases challenging the legislature passed and the governor signed to try to limit constitutional lawsuits against the state, whether it's Second Amendment, First Amendment, take your pick. They just don't want to be sued for violating the Constitution, yet they keep violating the Constitution.
But Maag says the other cases he has challenged this venue limits are in state courts.
Those are all in state court. None of them have been removed to my knowledge yet. And at least half of them, I don't think there's any mechanism to remove them to federal court by the state, because we're making two of their challenges at least solely under the state constitution.
But then in the Myers v. Kelly case, Illinois State Police Director Brendan Kelly motioned for an extension that was granted, but then he is now motioned for another extension. Whether that's going to be granted, who knows? But what's going on here? Maag provides a little bit of the context from his understanding.
The normal practice of the Illinois Attorney General, as near as I can tell, is constitutional rights litigation, is to repeatedly file motions for extension of time and try to delay the inevitable. I don't know if that's intentional practice and strategy or them being understaffed or a combination thereof, but it happens over and over and over again. If you look at nearly any constitutional litigation involving the state attorney general's office, it's motion for extension after motion for extension. It's unfortunately become the nature of the beast.
But is it just a procedural thing, or does this actually have a detriment to the plaintiffs in this case? Final comment from Thomas Maag.
Well, of course, there's the old maximum, justice delayed is justice denied. The longer resolution of unconstitutional actions are delayed, the longer unconstitutional actions are allowed to persist, and it really is justice being delayed, thus resulting in justice being denied. But eventually, we will win, I'm quite certain.
So we'll keep an eye on what's going on with all of those cases. It's pretty fascinating, as we've been every day practically reporting on some different angle when it comes to challenges against Illinois' gun and magazine ban and other Illinois gun laws. That's all I got for you today. Follow me online, Twitter, also known as X, Facebook, YouTube. Just search Bishop on Air, and we can connect that way. Email me, bishoponair@gmail.com.